Hello, everybody. Looks like we are now live. I'm George, one of the founders of SoloSuit. We're going to be talking about how to win your debt collection lawsuit today. Good to see everybody. Happy to go over some of the basics. We reserve most of the time for Q&A. So if you have a question, just go ahead and put that into the chat, and then Hannah will get to that via text, and I'll go ahead and do a verbal response on the video here. If anything's wrong with our audio and visual, just let me know. Looks like everything's working good, so that's great. A little disclaimer as we get going. I'm not an attorney, I'm not your attorney, so this is not a law firm. We're not your law firm. We don't represent you. There's no attorney-client privilege made in this webinar, else this isn't legal advice, it's just a webinar. Those are some things I say because of the friendly regulations on the practice of law. Alright, so just real quick, most people come to us when they're being sued for a debt. They use our service to respond to the lawsuit, right? So you can use our Debt Answer product. Let me just go ahead and show that to you real quick. I'm just going to pull that up. Let's see, I'll show you guys how it works. Just getting that open on my computer. Alrighty. So, people come to us when they're being sued for a debt. You can just come on here, you just click the reply to a debt lawsuit button, and click get started. And then you'll answer some questions on here, like what state are you from, and move yourself right along. A lot of people go for our premium package. It's $247, which is a lot cheaper than an attorney. Attorneys usually start at $1,000 to $3,000 for litigation. And with that, you'll be able to generate your response. And then we will file it for you in court, and we'll have an attorney review the document as well to make sure that you didn't enter anything incorrectly, you responded okay to the document. So that's the debt answer. And let's see. It has great reviews. A lot of people love us. Here are some happy reviews lately. We got Teddy saying, I'm so very grateful for this company that offered their highly professional expertise for free. A lawyer left me hanging after waiting to speak to them for 15 days. That's a different lawyer, it's not us. And only had 20 days to respond to the plaintiff and the court on the lawsuit against me. I was at a loss of sleep, and then I found SoloSuit searching online on how to even go about answering the court. This company took good care of me. This is a long review. I'm just skipping ahead a little bit. Used SoloSuit, got the answer filed. SoloSuit made it possible for me to speak for myself. God bless your company and everyone that works in it. That's great. Hear that, Hannah? We got the blessings of God from Teddy, so that's a wonderful thing. We got Dean, said simple, plain, easy. For a small fee, we filed it electronically, so that's good. Let's see, and then, let's see, we got Johnny. Took all the recommended steps all the way to the wire. $4,500 credit lawsuit, and then they settled it in front of the judge for $1,400. So that's a big win. Very glad we could help them out. Okay, so those are some great reviews there. And then what people usually do is after they respond to the lawsuit, they're usually going to come over here and then settle the debt. So they use our tool SoloSettle, Just answer a few questions and then send an offer to the collector to get it settled, because that's the best resolution for most people that are coming to us. All right. So with that said, I'm just going to jump into the questions here. Yeah, if you have a question, make sure you get it in the chat. Okay. We got a question from Miss. Arbitration this Friday. If I want to fight the debt, is this meeting something I want, or should I file a motion before? How to get settlement low as possible. Have to file our plaintiff discovery before hearing. I'm not sure what a motion B4 is, never heard of that one. If you want to settle, which it sounds like you do, and you already filed a motion to compel arbitration, so that's great. That puts you in a better position to settle. So now would be a good time to offer a settlement. If you haven't already, you should go over to Solo Settle and then make that offer to settle. We do have a service called we do have a service with Solo Settle where you can activate a law firm that will help you settle as well. We definitely recommend that because that gets the best results. Just this week, we settled a debt. Settled 3 debt accounts for one person. They enrolled all 3 accounts that he had, 3 different credit cards, and we settled over $30,000 of debt for him. Saved him a bunch of money. Got him onto a real good payment plan. He signed up for Solo Settle and then activated the law firm. So it's a big win for him. So if you want to get a result like that, definitely recommend that you do that. All right, Kevin. Hello, is it too late to file for arbitration now that a hearing has been scheduled? No, usually you can file for arbitration up until a point where judgment is given. Or like if you usually you can't file like after a hearing because usually judgment is given in the hearing. But before the hearing, yeah, you can certainly try to file for arbitration. It's up to the judge on whether or not he'll accept it, but it's worth a shot. Derek has my preemptory meeting. Lawyer told me in Georgia affidavits and statements are enough. I've been asking for purchase agreements since the beginning. I got nervous and filed a motion to arbitrate. Okay, not sure I'm following you every step of the way here. Sounds like you want the purchase agreement from the collector, but they can't provide it. Pretty common situation, right? The collector can't prove they actually owe the debt, can't prove that he even owns the debt. It's a real thing. Definitely want that purchase agreement. Filing for arbitration sounds like a good move. If you want to settle, you can use Solo Settle to make an offer. Okay. Daedry, should I respond to calls from the lender? If you've been sued for debt, you got to make sure you respond to the lawsuit by filing a paper answer document in the court. All right, that's what we do for you. Responding to a phone call will not be considered a legitimate response for purposes of the lawsuit. If you want to talk to them, yeah, you can certainly pick up the phone and talk to them. You can try to settle on the phone. Usually settling on the phone with a professional negotiator that negotiates settlements all day, every day is difficult. So a lot of people use Solo Settle because we will do that for you. We'll send in the settlement to them either on email, or if you want to activate the law firm, they'll actively settle for you and get the best results. All right. Muzi Kali. I would like to file a motion to compel arbitration and found my credit union's credit card agreement through the CFPB website that you listed, but there isn't an arbitration clause. All right, well, it sounds like you're out of luck. If there's no arbitration clause, then you can file a motion to compel arbitration, but it wouldn't be valid. It wouldn't be successful. Best situation or best outcome for most people in your spot is, again, to settle. So you can make an offer on Solo Settle to try to wrap up that lawsuit, make it so that the collector can't come after you outside of court or in court ever again because it's fully settled. musicality again. However, there is an arbitration clause in the membership agreement and disclosures on the credit union website. Would this motion still apply? Probably not. That's like for the terms of service on their website, it sounds like. You're wondering what you're being sued over is the contract of the loan, and that loan agreement on the CFPB is probably what governs that situation. Especially if the debt has been bought by someone else, then certainly the disclosures, terms of service on the website won't apply. Kevin, can I get a hearing rescheduled? Yeah, you'd have to file a document in court. You'd have to file like a document, essentially a motion to postpone hearing, a motion to reschedule hearing. Alright, so like a motion is just a document that asks the judge to do something. So if you want the judge to do something, you file a motion, and then you can add whatever you want the judge to do, you add to the rest of the motion. Like a motion for summary judgment is a document that's asking the judge to provide a summary judgment. A motion to postpone hearing is a document asking the judge to postpone the hearing. And usually those are granted in most situations. ASB. A debt collector is suing me. The process server keeps trying to serve me the court papers. Any advice? Again, we know I'm not your attorney. This isn't legal advice. This is just like general advice. Not necessarily applied to your situation. Generally speaking, we recommend accepting service, right? So if the process server is trying to serve you, and then they can't serve you because you're dodging the process server, the collector, most states will just be able to serve you by mailing the document to you, or by even posting it in a newspaper, if you can believe that. In those cases, it's less likely that you'll even know that you're being sued. So it's best that you just accept the service in most cases. Alright, Miss Charables, I meant, should I file a motion beforehand? The court appointed the arbitration. Yeah, that sounds good. Sim Harvey, should I request arbitration or request settlement? Is there an average base to settle the debt? You can try doing both, honestly. Both is probably the best option in most situations. Our stance on this is always evolving as we get more data. But from the looks of things, yeah, filing arbitration and then offering to settle is a good play. Like, because you're saying, hey, this is forced to arbitrate, so you probably aren't going to win the lawsuit, but also I want to settle because I recognize that you can still bother me outside of court, or you can try to bring a new lawsuit, so I want to settle this and actually get it fully wrapped up. So doing both is a good move. You can just do one right after the other, right? So you can generate the motion to the arbitration website, and then go right over to SoloCell to make an offer to settle, and take that motion and then file it yourself in court. Average base to settle the debt. Most debts that are in a lawsuit across the industry settle for about 75% of the total amount of the debt. That might sound like a lot. However, additional costs of the lawsuit, if you don't settle, are probably going to be about 1.5x, maybe down to 0.7x. So that means that if you don't settle, you should plan on paying twice as much as the lawsuit is worth at the end of the day. That's because if you lose the lawsuit, you'll be paying statutory interest, which is an additional 10% interest rate on top of the credit card interest rate. You'll also be paying plaintiff's attorney's fees. You'll also be suffering garnishment. Alright, so because of that, settling for 75% of the total amount of the debt is not a bad outcome. That said, SoloSuit right now, SoloSettle, is on average settling for 71% of the total amount of the lawsuit. So that's leading to big savings for our customers, especially when you're adding in and factoring in the additional costs of the lawsuit. Debts that are not in a lawsuit settle on average for 45%. So that's a good place to start, right? And that said, it's a range. We see debts settle for 20%. We see debts settle for the balance in full. You just want to stick a number in the sand, you can offer like 50%. But really, it's usually based off of like how much you have to pay and what works for you. If you want to do a payment plan, again, you should do Solo Settle and then activate our partnering law firm, and they'll be able to work out a payment plan settlement for you. Deidre, I would like to settle. Awesome. It's a good choice. Jasmine, I was served. I need to file a court date electronically. Do I try to fight and ask the collector to prove the debt and hope they can't, or settle? I'm not sure what I need to file a court date electronically means. Sounds like you need to file a court document. So you're served a lawsuit. Next step is filing a response to the lawsuit. You can use us to do that. And then next step is offering to settle. All right, so you want to respond, then you want to try to settle. That's what you want to do. You can do both of those things on our site. So responding to the lawsuit gives you the leverage needed to settle. If you don't respond to the lawsuit, you have no leverage to settle, and you'll just end up automatically losing your case. Sim, the debt limit expiration in Georgia is 8 years. I think you mean the statute of limitations. I'm way over this. Is this a leverage point in debt settlement? Yeah, 100%. Yeah, if the statute of limitations has expired, you have a tremendous amount of leverage to settle because you have a very good rationale that the plaintiff is actually just going to lose the lawsuit. And you might actually want to push that, right? I think most people, if the statute of limitations really has expired, most people are just going to push that in the lawsuit to get it dismissed and essentially, effectively, like settle for $0, right? That's effectively what that looks like. What does arbitration entail? Question from Sim. So arbitration is a process for resolving a dispute or a lawsuit outside of court. So instead of having a judge, you have an arbiter. Instead of having a court, you have just an arbitration program. So it's like private dispute resolution. Most credit card contracts will require AAA arbitration or JAMS arbitration. Those are two organizations that provide the arbitration. And our motion to compel arbitration triggers JAMS arbitration, I believe, if that's an option. And then the plaintiff has to pay usually about $5,000 or so to begin arbitration. Most of the time it's not worth it for them to pay that, so they'll drop the lawsuit. However, just because they drop the lawsuit doesn't mean they're not going to try to come after you outside of court to get the debt. It also doesn't mean that you don't owe the debt, right? It just means that the case is going to be dismissed. That's like what it means. So usually you'll want to settle anyways, if you don't want to be bothered by them. And if you also want like your credit to be repaired, you're probably going to want to settle anyways. Okay. My next hearing is November 2nd. Is it too late to file Solo Settle with you guys? I appreciate that question because sometimes people are like, my hearing's in like 15 seconds. Can you send an offer to settle right now and get it in time? Or like, can you respond to the lawsuit? My deadline is in 10 minutes, right? So I appreciate that you're wondering about that. That's plenty of time for sure. It looks like that's like 3 weeks. You can totally file. We start negotiation on settlement pretty much immediately when you submit a Solo Settle. If you want to activate the law firm, which I highly recommend because you're going to get much better results like that, that'll also be enough time. They do need more time. Like they like to have 1 to 2 weeks at least before a hearing. And they also like people to activate them basically as soon as possible. Do you offer answering small claimed lawsuit letter? Yeah, you can use this to respond to small claims. Most debt lawsuits aren't in small claims, but if it is, yeah, you can use this. It has to be a debt lawsuit, and you can use this to respond. All right, folks, just wrapping up. We just got another minute or two here. Jasmine, yes, I need to file an appearance and answer electronically. Can you guys help with this? Yes, we can file an answer. We don't always do it electronically. Sometimes we do it over the mail. We just do it by whatever filing system gives us the best results. So you can use this to file an answer. Usually an appearance means an answer. Hearing already scheduled from Kevin. Anyways, to get it rescheduled and delayed as much as possible. Yeah, you just gotta file a motion to reschedule the hearing. If you're just trying to delay without any reason, the judge probably isn't gonna go for it, but if you have a real reason, you can do that. Alright, then this is the last question here from Derek. Better outcome, settling or trial? Because no purchase agreement after asking, and lawyers only have affidavits and a stack of credit card statements. That's ultimately up to you to determine. Basically, if you owe the debt, if you agree that you owe the debt in some way, then I would certainly move toward settlement. But if you do think you're going to win a hearing because they messed up the documentation, or you don't owe it, then oftentimes it's worth a shot. But totally, sometimes these plaintiffs can prove that you owe the debt and win the case. So it's a bit of a risk. You're kind of rolling the dice, right? So settlement is usually a situation where both sides lose a little bit or both sides win a little bit. In a trial, it's winner takes all. One side either wins big and the other side loses big, or this side wins and this side loses. Right? So if you go to trial, you're either going to come out owing the debt plus that 1.5x, which will be bad news, or you end up owing nothing. And technically, if you win, the collector will probably owe you money if you could try to get them to pay for your solo suit costs, because oftentimes they do owe attorney's fees if you use an attorney. All right, folks. That's it for today. Again, I'm George. Thank you for trusting Solo Suit with your case. We are in your corner. We want you to win. Always feel free to reach out if there's anything we can do for you. And again, main takeaway: if you've been sued for a debt, use us to respond to the lawsuit, and then make an offer to settle and activate that partnering law firm to get the best results. All right, good to see everybody. Take care.